How does someone living in an inherited property affect the ability to sell it? Someone living in an inherited property can delay or complicate a sale, but it usually does not automatically stop the sale. The first issue is who has the legal authority to sell and sign the deed right now, either all the heirs or devisees as co-owners, or a properly appointed personal representative who has authority under the will or a court order. The second issue is what legal right the occupant has to be there. If the person living there has a lease or tenant rights, a buyer may have to take the property subject to that lease, or the lease must be ended lawfully before closing. If the person is there only because one heir gave permission, that does not usually create ownership rights. But it can still create a practical problem if the occupant will not move out voluntarily. Buyers and title companies often expect vacant possession, so an unwilling occupant can stop a normal closing until there is a written move-out agreement or a formal removal process. And if the heirs do not all agree on selling, a partition case can be filed to force a court-supervised sale, which takes additional time and requires notice to all owners. The bottom line is that occupancy changes the timeline and the strategy, so it is important to confirm who can sign and address the occupant's status early before listing the property or setting a closing date.